Hello everyone, myself Vishu Sharma, Assistant Professor, School of Law, City University, Ludhiana. So today I am going to discuss a topic of application of a execution. So application of a execution. So in any of the suit, there are the basically three stages in any of the litigation. First one is the institution of the litigation, second one is the adjudication of the litigation, and the third one is the implementation or the enforcement of the litigation. So enforcement of the litigation is known as the execution. So basically, firstly, it is a petitioner has to file an application before the court, and after the proceedings, after the arguments, evidences and all, that petition can be adjudicated by the court. So the conclusiveness of that particular adjudication, conclusiveness of that particular judgment is called as a decree, and the enforcement and to give effect to that particular decree is known as the execution. So execution basically is not given in the any of the code in the civil procedure code. So as we know that if any person who is aggrieved and wants to claim something has to go to the court, right? Similarly, in the case of execution also, the parties who want something and the parties who wants to execute that particular decree which is passed by the court has to go to the court and make an application. Execution is not defined in any of the code. In the civil procedure code, basically execution is an enforcement, it is the implementation, it is the to get effect to the decree, right? And basically to give the fruits of the judgment to the decree holder. So execution enables the decree holder to compel the judgment debtor to mandate the orders of the court. And as I know that the execution is not defined in the code, but in Ghanshyam Das versus Anant Kumar Sinha's case, the Supreme Court observed that there are numerous provisions are there, exhaustive provisions are there of the civil procedure code which is dealing with the execution. So here section 34 to 74 which are dealing with the execution. So section 34 to 74 and order 21 of the CPs is dealing with the execution. So now we'll discuss that what is the application of the execution and that how the application can be made, who can made, where to made, and against whom the application can be made. So as we know that for any application, for any plate, we have to go to the court. Similarly, for the execution also, it is the party who has to go to the court. So execution basically is a facility which is provided to the decree holder, and it is the court who facilitate the decree holder to execute the decree. It is not an obligation upon the court to execute the decree. So basically the court cannot execute the decree suo motu. Court has no obligation, court has no authority to execute the decree suo motu. There is a particular limitation time is given, limitation period is given. Within that, the decree holder can make an application for the execution. So there are certain rules which are dealing with the that how the application can be made, where the application can be made. So there is a rule 10 of order 21 which is dealing with the that where we can make an application for the execution. So firstly, generally, as we know that, so the decree holder can make an application in that court which passes the decree. So the court which passes the decree having authority, having the jurisdiction to make an application and to make the execution of the decree. Second one is when the officer is appointed, in that situation the application can be made before the officer which is appointed on the behalf of the court and by the court. And the third one is the court where the decree is sent for the execution. So sometimes the parties, the respondent and the petitioner, they are residing apart from each other and different states, or you can say different cities. So in that situation, the decree can be sent to the another state or another city for the execution. So only if the court which passes the decree having no jurisdiction to execute that, in that situation that can be sent to the other court. So in that situation, it is the court which passes the decree can send the decree for the execution to the another court suo moto, or as well as upon the application of the decree holder. Decree holder can ask to the court to send the decree to the other court, or it is the court which passes the decree if seems fit, that can also suo moto can transfer the decree or can send the decree for the execution to the another court. So there are sections from 37 to 45 which are dealing with the that where we can move an application. So basically section 38, 39 and 42 dealing with the transfer of the execution. So there are so many cases. If the property is situated in the different city, if the respondent is judgment debtor is residing in the different city, if the business is in the different city, and if it seems that the if the in the pecuniary cases the court which passes the decree lapses the jurisdiction, in that case also they can send or they can transfer the decree to the other court. They can send the decree to the other court for the execution. Now, who can apply for the execution? So as we are discussing that for the execution of the decree, application should be made. The application should be made to the court and all. So that who can make? Firstly, according to the Rule 10 of the Order 21, it is the decree holder. It is the decree holder who can make an application. The decree holder is the person in whose favor the decree has been passed. That person has the ultimate authority to execute the decree. Second one is the legal representatives. Legal representatives in the case of death of the decree holder. So if the decree holder dies during the proceedings of the court, or even after the proceedings of the court, even after the judgment, so in that case the legal representatives of the decree holder can make an application to the court and can make an application for the execution. They have to give the reasons that why they are going to represent. Third one is the representatives of the decree holder. So if the decree holder is alive, but the decree holder is living outside the country or outside that particular jurisdiction of the court, so in that case he can appoint the representative, he can make a power of attorney and can give the authority to any of the other person that can represent the decree holder for making an application for the execution. Then any person who is having the interest. So if in the decree, if any person is having the interest, that can also make an application. So if the decree holder in whose favor the decree has been passed, but before that property sold out to the other person, that property is under mortgage, that property is under sale. So in that situation, the person, the mortgagee, the lessor who is having the interest in that particular property can make an application for the execution. Then transferee of a decree holder. So if the decree has been passed in the favor of the decree holder and that property is already transferred to the other person, and that property is if the decree holder transfer the rights upon that particular property to any other person, so in that situation the transferee of that particular decree can make an application for the execution. So and the last thing is that if there are more than one persons are there as a decree holder, if there are more than one persons are there, in that situation any person from those more than persons as a joint decree holder can make an application. For example, if there are 4 persons are there, 4 persons are there as a petitioner, and the decree has been passed in the favor of those 4 persons. So any of those persons as a joint decree holder can make an application for the execution, and the person who is having a special interest. So like as we know that the unborn child is also having an interest. He, like if any, in the case of partition, in the case of succession, his is interest to be reserved, right? So after taking the birth, after having the like in the life, he can also claim the rights and he can also claim the interest. So if the decree has been passed in his favor, so after taking the birth or after attaining the age of majority, he can also make an application for the execution, but he has to prove that he was having some interest. Now, against whom the decree has been passed? So as we know that there are petitioners, one side is a petitioner and one side is a respondent. So same as the decree in whose favor the decree has been passed, that person is called as a decree holder, and against whom the decree has been passed, that person is called as a judgment debtor, right? So against whom the decree has been passed, that is a judgment debtor. Firstly against whom against the judgment debtor. Secondly, if the judgment debtor is dead, right, then the legal representatives of that deceased judgment debtor can make an application for the against that particular deceased, it is the decree holder can make an application, and the representatives of the judgment debtor, the decree holder can make an application against the representatives of the judgment debtor. And in case of the money cases, in the case of breach of contract, or in the other cases in the Negotiable Instruments Act under, so if there is any surety is there, so against that surety also the execution application can also be made. Now the forms of application. So basically, according to Rule 11 of the Order 21, there are basically two forms of the application are there. One is oral application and the second one is the written application. In the oral application, it is the decree holder can ask to the court on the spot at the time of judgment to execute the decree. Basically, in the case of payment of money, mostly the oral execution is made. And second one is the written application or a written application. So in all other cases, except from the apart from the payment of money, in all other cases the written application can be made by the decree holder. That application must be in a written, must be signed by the decree holder, and must be signed by the applicant, any applicant other than the decree holder, or that must be acquainted with the particulars, right? So any other person, as we have discussed that the legal representatives, the representatives, or any person who is having the interest, that can be applicant, or that the signatures of that applicant must be given on the particular written application. Now, what are the contents which to be mentioned in the application? So in every application for the execution, the suit number must be there. Suit number is when the party is going to file an application as a petition, right? So while making any petition, a suit number is given to the particular petitioner, or a suit number is given to a particular petition. That suit number must be given into the application. Suit number, for example, 102/2000, 102/2001, that is a number which is given to every of the case, right? Then the name of the parties. Name of the parties means the name of the person who is making an application, right? So here firstly we have to mention the name of the decree holder, that who was the decree holder, and if the decree holder is making an application, then he can mention his name, his father's name and all, right? Then if any other person like the legal representative or any other person is making an application, then he has to mention firstly the name of the decree holder, then name of the legal representative or any other person who is having the interest, and they have to mention the relation with the decree holder, right? then the date on which the decree has been passed. This is the most important thing that must be mentioned in the written application, the date of the decree. Why so? Because there is a limitation period is given under the code for the execution of a decree, that is 12 years. Within 12 years from the date of the execution, from the date of the decree, the application can be made within 12 years. And in the case of permanent injunction, in the case of mandatory injunction, it is 3 years only. Within 3 years, the execution can be made. But if the person is not making an application within that prescribed time, he has to give a show cause notice or has a give a reasonable cause, right? So that's why date of the decree must be mentioned into the particular application. Then payment or adjustment, if there is any adjustment between the decree holder and the judgment debtor, that must be mentioned in a particular application, right? For example, in the compromise cases, when during the proceedings of the case, the petitioner and the respondent, they undergo a particular compromise. Firstly, at the time of judgment, they have to submit a particular compromise deed before the court, and after submitting that court, when the court is giving the judgment, that compromise deed and the number of the compromise deed and what are the adjustments have made must be mentioned in a particular application. Then the amount of interest, if in the case of payment of money or in other cases the interest which is to be paid by the judgment debtor, that amount of interest must be mentioned on a particular application. Then if the cost is awarded means if any fine is imposed upon the judgment debtor, and if there is any compensation is awarded to the decree holder, so in that case that also must be mentioned in the particular application. And the last one is, and the most important one is, mode of execution. So by the mode of execution, it is the court who can execute the decree, right? It is the mandatory for the decree holder to mention the mode, that by which mode he wants to execute that particular decree. So there are basically certain sections are there, which are dealing with the modes of the execution, and order 21 of the CPCA, which is dealing with the mode of the execution. There are the rules 11, 12, 13, 15, 16, 18 and so on. They are dealing with the modes of execution. So first mode is the arrest and detention. So in the as we have discussed that the application can be made orally or in the written form. So in the oral application, as we have discussed that in the case of payment of money, the oral execution can be made on the spot. It is the decree holder can ask to the court and can make an application. So in the case of arrest and detention, in the case of payment of money, on the spot the judgment debtor can be arrested, can be detained by the court in the case of payment of money. Otherwise, it is the decree holder who can mention in the application that by arrest or by detention he wants the execution. In the case of basically in the maintenance cases, in the case of recovery of suit, or in the cases of check bounce cases, basically the parties are doing this type of execution. They are claiming the arrest and detention of the judgment debtor. Right now, the judgment debtor can be arrested by the court at any time, at any day, within the prescribed time, at any day, on any day, at any time. But no women can be arrested before the sunrise and after the sunset, right? And no police officer or no person appointed by the court can be can step into the dwelling house for the arrest of any person. And no person can be arrested or no person can be detained into the court before giving the notice. Notice must be given to the judgment debtor before the arrest or before the detention. And the second one is the attachment of the property. Attachment of property is like a very important part of the execution. So in the attachment of the property, both movable and immovable properties can be attached by the court. In the case of movable property, whatever the property belongs to the judgment debtor, in the name of the judgment debtor, that can be attached by the court and that can be sold out by the court. So after the attachment of the particular movable property, the notice of the sale must be given to the judgment debtor, right? So without giving the notice to the judgment debtor, no sale can be made in the case of movable property. In the case of immovable property, same as in the case of movable property, in the case of immovable property as well, the notice must be given to the judgment debtor, right? So when the person is ready to pay the amount, then the property cannot be attached, right? And when the person paid the amount to the decree holder, in that case also the property cannot be attached. And if the person is arrested and detained in the custody, and while the arrest, they made the amount, then they can be released from that particular arrest, and no property can be attached or can be sold out. Only in the case when the person is having no money and the person declared that he is having no money, in that case only the property can be attached. So any property, any land, any house, any shop, any type of immovable property which belongs to the judgment debtor can be attached and can be sold out, right? So after the attachment of the property, it is the court who appoints the receiver to receive the amount from the sale. So after appointing the receiver, it is the court who has to make a declaration. That declaration is called as the proclamation, right? So the proclamation should be made by the court for the sale of the immovable property. Declaration should be made by the court for the immovable property. Unless the declaration has been made, no sale can be made by the court. So there are certain particulars which must be given in that particular proclamation. Firstly, the name of the property. Name of the property means whether it's a house, whether it's a shop, whether it's a land, that must be given in a particular application or that particular declaration or proclamation. Then date of auction. Date of auction means the sale of immovable property must be made only by the public auction. By the public auction the sale can be made, so that the proclamation must. So in that case, the date, the time, the venue where the execution or where the auction is going to be held, that must be mentioned in a particular proclamation. Then the name of the receiver, who is going to receive the amount from that particular money, that must be mentioned in the particular proclamation. So after declaring the auction, after declaring that particular proclamation, it is the court who can sell out the property. So the person who buys that property has to pay the amount to the receiver, which is appointed by the court. So for initially he has to make the 25% of the amount at the time of the auction itself. Rest of the amount he has to pay within the 15 days from the auction. So now the question arises, if the judgment debtor is willing to pay the amount, in that case if the judgment debtor is willing to make the amount, then within that 15 days he can make the amount, or he can pay that amount to the receiver or to the court. But before paying that amount, he has to give notice to the court that he is willing to pay the amount, he is ready to pay the amount. Then he can go to the court and can set aside the sale which is made. right? Now the question arises, once the sale is made, that how it can be set aside. So once it is the decree, it is the buyer who purchases the property or purchases that immovable property in the auction, he has to pay the initial amount 25% at the time of auction. Rest of the amount he has to pay within 15 days. Once he paid the amount, that must be published by the court that he is the owner of the particular property. So until and unless the court publish that thing, the judgment debtor can pay the amount, can set aside the sale. So in that situation, it is the buyer who purchases the property can recover the amount, and the decree judgment debtor can pay the amount, can reserve the property. So these are the basically modes that by arrest and by attachment, by arrest and detention and attachment of the movable as well as immovable property. And the last one is the receiver of the appointment of the receiver. So in the case of payment of money, it is the court who can appoint the receiver, and the judgment debtor can pay the amount to that particular receiver, and the execution can be made. So these are the modes of execution, and in the application of the execution, this mode of execution must be mentioned, right? So there are certain persons that garnishee must be appointed by the court, that in the case of if the property, immovable property is belonging to number of persons, so and there are number of decree holders are there, so that garnishee or that particular person can make the distribution, can make the writable distribution among them according to their interest, right? So in the end, in the conclusion, I will say that the basically execution is the enforcement, implementation of the decree, or to give effect to the decree, so that the judgment, so that the decree holder can get the fruits of the judgment. No doubt there is no any section is there, no doubt there is no provision is there regarding the execution in the code, but there are the provisions, there are the procedure is given in the CPC, which is followed by the court. Thank you so much.